All right, Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you.
But the judge wasn't in the right place at the right time because he never should have violated the law or violated what the rights were in order to make sure that his lawyer, that Young Thug's lawyer, wasn't there in a conversation that they wasn't. Listen, you talking about, it's not just about the conversation being recorded. You talking about somebody's life on the line. And there's too many holes and too many issues and too much corruption, especially down there in Georgia. And you know me, I'm the type of person that always says that, the things that we celebrate the most from the culture is trash. But I also say, because two things can be true at the same time, that I do not stand on the court of public opinion in order to make sure that we convict somebody in law. And so at the same time, and every time he goes to speak, Young Thug's lawyer, every time the lawyer goes to speak, the judge interrupts him in order to try to get his rocks off, because the only thing that he cares about was how he found out it don't matter how I found out the information. That ain't the issue. That's unless we out here doing crime together and you snitch on me, then that don't matter. The only thing that matters is whether or not you did things the right way, because otherwise you got to free that man. In a way that I've been following this trial and paying attention, and I haven't commented a whole lot on it, and it's the longest trial, and I know it's costing Young Thug a lot of money and all of this. Listen, man, I do not believe that our justice system is above reproach or above being held accountable. And in this instance, I cannot, in good conscience, if I am a person that's in there, convict him in a court of law, and I think that they need to free him. Absolutely free him. There's no way that you can continue to go down this path. And again, even though a lot of the culture may be trash and who knows what he's doing, but every single person in the United States of America deserved their day in court, and he decided to try his day in court. And the judge and the prosecution is fumbling this 100%. And so in this instance in particular, I got to stand with Thug.
I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going
Sir,
to
I
breach
don't
that
want to. I
confidence.
don't want to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who
cannot
raised it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in
Don't
time.
you, Judge? You listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From
that
whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk
well
about
then you'll be in custody until then, because
then-
because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well, then, other than
answer
if
that
you were
on the
sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor,
And if that person gave you that information or shared that information with you, she probably violated privilege.
well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well,
ex
it's because
parte.
she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got this
I'm not gonna have any
information-
further- I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence.
This is insane because the lawyer is absolutely right. Listen, if that was the conversation that was had without his knowledge and he was supposed to be there, who knows what's going on behind the scenes, or what kind of privileged information, or what kind of conversations or deals are being worked out, or how people is getting finessed and all this other stuff. I just don't trust it. If you can no longer put your confidence in the legal system and the justice system and the system that's supposed to be overseeing our freedoms and who goes to jail and who's not and whose life is going to be hanging in the balance, you got to throw the whole thing away. There's no way that I could ever justify the behavior from this judge, and the judge is pressing him like he a lawyer. The judge is pressing a lawyer like the lawyer is on the stand for his life, like he murdered somebody.
That's really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your I'm going to deny your
Becoming-
motion. I'm going to deny your motion.
I
for
understand that you
mistrial.
spoke with a
And when-
witness outside of our presence.
And
this
whenever,
morning.
yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue
Oh,
that
that's
was
a real
outside
lawyer.
our presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
didn't we
another day.
exclude in the first place? I didn't know about this stuff.
That's for another day. So,
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele,
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it
Does the
supposedly.
state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
State
why
does.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it, and then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6, and I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
well,
entitled to the
that leads to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1, paragraph
you've
12.
already said that. You've already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms. Lowe.
okay, excuse me.
Okay. All right.
Dude standing on business, and I respect it. I got so much respect. I think that his stock just went up 2,000%, man.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate.
She not ready. She not ready. The reality is that what he said was they should have been there. The conversation should have never been had. And it actually messes up what it is that they're trying to do with regard to the trial and making sure that his clients stay free. I don't really know why this is an issue. And I seen that, later on, I guess, the judge actually has him arrested. I don't know if I could see that.
Given said whatever this morning that.
If there is any.
Well, then you've made a.
Wait, did they actually arrest him? Yep, they did arrest him.
Okay. Yes, sir. You certainly may.
Against Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Crazy. This is insane. It's absolutely insane. So I'm curious as to what you guys think. I know we've been having extensive conversations about this, but this is important. We're going to go over the testimony tomorrow morning on the Millionaire Morning Show of the material witness, and we're going to give our thoughts. I'm curious as to what y'all think. Make sure y'all tap into the Patreon. I just uploaded Stock Club yesterday. I uploaded Stock Club yesterday to restream for y'all to be able to tap in and be able to get into that and get all of that information so you can know exactly when you need to take out profits from the investments. And we going from there. I love y'all. I appreciate y'all. Can't wait to read y'all comments on this one.